Hello, students. Welcome to the RHIT exam review for the legal domain, commonly known as Domain 6. Your presenter is Dr. Nisa Jenkins, professor in the College of Health Sciences. The content of Domain 6 covers a few of the following elements. Insurance of confidentiality of the health record, whether it's paper or electronic. Demonstrating and promoting legal and ethical standards of practice. By now, you should all be familiar with the fact that HIMA publishes a code of ethics for health information professionals. You can find those on the ahima.org website. Following state-mandated and/or organizational record retention and destruction policies. These are very important, and we'll talk more in depth as we move through this presentation, but want you to know that it's important to follow these according to the state that you're in. And some of us work from home and we work virtually, so we may cover several states. So we'll need to be familiar with all of the legalese associated with different states. The health information professional serves as a custodian of the health record, whether it's in paper or electronic format. I can't stress that enough. Just because we're moving to a more electronic environment, some environments are still hybrid where they're using paper and electronic, it doesn't make the paper obsolete. We are still in have responsibility for paper and electronic versions of the health record. We'll talk more about responding to release of information requests from internal and external requesters. What should the release of information form cover? Who should sign it? Who has the responsibility for a minor or a patient who cannot sign or speak for themselves? We'll talk about responding to and processing patient amendment requests to the health record. We'll talk about the custodian as a representative of a facility in court related to matters as it applies to the health record, like subpoenas, depositions, court orders, and warrants. We'll talk in depth, first of all, about protected health information and disclosing protected health information and whether or not an authorization is required for the disclosure or not. It's important as health information professionals to be familiar with what type of disclosure requires an authorization. And from time to time, we may have to go back and revisit our policies, procedures, the law as it pertains to the state that we're in. But some of those requests can include IRS requests, workers' compensation requests. As you know, when an employee is injured on a job and workers' compensation is picking up the bill for that patient, and they may want to know what's going on with the patient, what's the treatment, course of treatment like, what's it entail. Marketing communication, such as a news agency. News agency doesn't have the right to just come in and take information when perhaps there's something going on in the community, someone's been injured or something has transpired that's affecting a community in a major way. They want to report, but they'll need an authorization. Authorizations are also required for third-party payers with the exception of treatment, payment, and operation. So someone who's being treated and your insurance company is paying for that, they may not need an authorization for that. HIV-related information, mental health-related information. Authorizations are needed to obtain that information, so it's important for health information professionals to know that. Domain 6 also covers PHI disclosures where authorizations may not be required. It's always important to check when the word not is used, but some of those disclosures could include Medicare, Medicaid, military and VA activities, protected services for the president and others. When I worked in mental health from time to time, there were people who would threaten the life of a president, and they would come in and want to obtain that information. And it depends on what information they're trying to obtain as to whether or not that information did not need an authorization. It wasn't that we could just give that information to those people who were requesting it. Correctional institutions for the provision of health care. So if there's an inmate who's actually being treated for a disease or some type of injury, something like that, and they are the property of that correctional institution, an authorization is not required. One of the other factors as it relates to legal, it's so important for health information professionals to understand the different aspects and be familiar with how to adhere to disclosure by standards and regulations. It's important that we understand that we may not have a complete knowledge of it, but we have some familiarity, some working knowledge of it, so that we can be familiar and help others who are trying to find out whether or not it's okay. What does this HIPAA privacy rule actually mean? It's important for us to understand that and be able to disseminate that information to the organizations that we are working with. Now, just to talk a little bit about the Health Insurance Portability and Accountability Act, which is, I want to make sure that you understand that acronym, HIPAA, should always be HIPAA and not HIPPA. I've had so many people always put down because of the way it sounds. Actually, I think it's just a common mistake that happens. But just know if you see this on the exam, and it's HIPAA, and it stands for Health Insurance Portability and Accountability Act. Now, this act requires the Secretary of the U.S. Department of Health and Human Services to develop regulations protecting privacy and security of certain health information. The Health and Human Services Department published what is commonly known as the HIPAA Privacy Rule and the Security Rule. Now, the Privacy Rule establishes national standards for the protection of certain health information, and the security standards for the protection of electronic protected health information, and establishes a national set of security standards for protecting certain health information that is held or transferred in electronic format. And today we see a lot of that going on as we watch the industry transform, the healthcare industry transform to a more electronic environment, not only in health information but other areas of healthcare as well. They've made strides in healthcare with being able to do things through technology that they couldn't do 10 years ago. So the HIPAA privacy rule is the key law covering confidentiality of protected health information and security. It has 5 sections. Title I, Healthcare Access, Portability, and Renewability. Title II, Preventing Healthcare and Fraud Abuse. And today it's so important to understand that we need to prevent healthcare fraud and abuse because there's so much, whether it's intentional or unintentional, there's a lot that goes on. Title III, Tax-Related Health Provisions. Title IV, Group Health Plan Requirements. So a health information professional should have some working knowledge of these 5 sections of the HIPAA privacy rule. Prior to HIPAA, no generally accepted set of security standards or general requirements for protecting health information existed. Can you believe that in the health care community? So, prior to this act, which was published in 1996, there was nothing really to protect. And I don't know if we saw as much of the things that we see now in terms of abuse, fraud, medical identity theft, but we definitely needed this HIPAA privacy rule, especially as it relates to portability of your health insurance and knowing that you can move to a different position and still be covered. Because that's important. And I think as healthcare consumers, we don't want to be worried about whether or not I'm going to be covered because I have a pre-existing illness or my family member has a pre-existing illness. Let's talk a little bit about the HITECH Act of 2009, the Health Information Technology for Economic and Clinical Health Act, which is known as the HITECH Act. And yes, you should know what that acronym means. This legislation was created in 2009 to stimulate the adoption of the electronic health record. And we still see that going on. We still see so many healthcare providers trying to come on board or coming on board. Now it's time to update their systems. Now we're looking more at the interoperability issues. Can my system speak to another doctor's system in order to make sure that we provide the best continuity of care for patients? So it's important that I think that the healthcare industry has the capabilities to interoperate and to have electronic health records. And President Obama signed HITECH into law on February 17th of 2009 as a part of the American Recovery and Reinvestment Act. And the American Recovery and Reinvestment Act is sometimes noted as ARA. It's a multi-level law which includes stimulus funding for health information technology and important HIPAA privacy rule, which are located in the HITECH portion of the ARA Act. It's a lot to remember, but just familiarize yourself with HITECH, ARA, electronic health records, stimulating the adoption of electronic health records in healthcare. Now, just to speak more in regard to HIPAA, individuals or healthcare consumers, as I like to call them, have the right, certain rights under HIPAA, the Health Insurance Portability and Accountability Act. They have the right to access their health information. They have a right to request an amendment to their health information. So if they think that there's something in the records that's not stated correctly or not completely accurate, perhaps they they told the doctor one thing, he documented something else, and the patient reviewed the record and now wants to request an amendment. HIPAA gives them that right. They have a right to request an accounting of disclosures. Who did you disclose my information to? I would like a complete list of those people or individuals or organizations that you provided my information to as a patient. Right to request restrictions of protected health information. Don't send my information to this person, or don't send my information in this format. Some people don't like to have their information shared or left on a voicemail. Right to request confidential communications. I would like to have my information remain confidential, to be housed in a specific place where no one else can access it. And a lot of times I think this is relevant when we see superstars who are admitted to an organization and or healthcare organization, and there are people trying to find out why this elite person or superstar has been admitted. They have a right to request confidential communication, a right to complain of a privacy rule violation. And one example I like to share is earlier on in my career when a friend of mine asked me whether or not my dad was in the hospital, and she found that out from someone who worked at the hospital, which was a mutual associate of ours. At that time, not really understanding the HIPAA and just being, and I don't even know, probably not in school or at that point maybe, but just thinking about, wow, why did she tell her that my dad was in the hospital? That's something that an individual would want to reveal if they felt it was necessary. It's important to understand what a breach is. First of all, breach, we've seen them in the media where information has been compromised or information has been hacked, and other people who are associated with that information who maybe perhaps is a healthcare consumer who's given their information, or as for some reason they have their information in a database and it's been breached, they have a right to know. And so the American Recovery and Reinvestment Act requires all covered entities and business associates to be subject to the FTC, which is the Federal Trade Commission regulation. I like this because it's not the recreation of something, but it is the complementary or the direction to other regulations that are already in place, but we just needed to be directed and have some guidelines in healthcare to make sure that folks are notified about breaches. It's an unauthorized acquisition or access or use of or disclosure of PHI, which compromises the security or privacy of such information. It's important that we are notified. And there's some parameters and criteria that must be followed in terms of, notifying the Office of Civil Rights and to determine whether or not this actually was a breach that requires notification, how many people were impacted. And so it's important to understand that. So as you're studying the HIPAA regulation, also, take a look at the breach notification requirement. The HIPAA privacy rule has administrative requirements: designation of a privacy officer and a contact person to receive complaints. So this is a requirement, not an option. There has to be someone who's identified in an organization as a privacy officer. A lot of times you'll see in healthcare where the health information director, manager may also be the privacy officer. Requirements for privacy training. How often are employees trained on privacy? Which employees are trained? What information is disseminated about privacy each time a training is conducted? Training on privacy safeguards. That includes administrative, technical, and physical safety. Are there passwords? Is there the ability for encryption? Are there screensavers? Are the doors locked? Are the computers covered so that people standing afar off can't read information? There's standards related for related policies and procedures. We need policies and procedures to provide directives, and not only directives, but to be consistent in how we handle things. Civil and criminal penalties. Some of those may actually be monetary. I know in the media I've seen more recently, organizations being penalized monetarily for breaches. Domain 6 also covers information about the Fair and Accurate Transaction Act under what is known as FACTA. FACTA is financial. It requires financial institutions and creditors to develop and implement written identity theft programs. It's so important. I mean, identity theft is on the rise, but more recently we've seen it be more visible in the medical community. So there needs to be some red flags that are set up to indicate a possibility of identity theft. Perhaps a patient is using another patient's medical insurance. They're using their name. They're using their social security. What kind of red flags are set up? Perhaps they've already been notified that a person's identity has been stolen. And so that would be very important to have some type of red flag set up, that this is a common name that has been commonly used. And I think every day as health information professionals, as we become more involved in looking at health information, those red flags go up in our minds automatically when we see it, and perhaps we catch a name and maybe we see something that is very similar when we're looking at the data or information that will lead us to think, hey, this may be something that has to have a red flag. And healthcare organizations meet the criteria, many of them do, as a creditor. So they must meet these red flag rules here, and here are a few of those: limiting access, requiring user IDs, eliminating open network jacks in unsecure areas. One place that I can think of commonly that uses open network jacks is the airport. When you're waiting in the airport, and especially in the Delta area, you'll see open network jacks where you can kind of plug up and just use the internet, that kind of thing. So you can see how those things can be a threat, especially when someone can hack into those or set up false networks, that kind of thing, or when you have a phone and you can use what's called the it escapes me right now, but each of our phones have that ability where we can actually set up a nice little network, and it's called a personal hotspot. But sometimes people set up fictitious hotspots. So it's important to understand and know that those areas are unsecure. Routine audit access to PHI. So there needs to be an audit trail. That audit trail is done electronically through the system. Who accessed it? When did they access it? And in my example earlier on about elite people or superstars who go into the hospital and people try to access their records, well, they're found out through audit trails. There's someone who goes, does an audit trail, looks to see who actually had access to that information, and did they have a need through their job responsibilities to have access to that information. So it's important to adhere to the disclosure standards and regulations that have been published for us to do our job and to help our organizations be familiar with and have a level of respect for these standards and regulations. Some other disclosures, standards, regulations, bylaws, medical staff appointment and privileging, labor laws, Americans with Disabilities Act. We need to make sure that we're familiar with what these particular laws and acts require as a standard or regulation. in the establishment of labor laws, of course, the American with Disabilities Act. We want to make sure that we understand, how does that impact us as custodians of health information, but then how do we protect those who have a right under these laws or privileges and things like that. Demonstrate and promote legal and ethical standards of practice. Health information professionals are responsible for maintaining and promoting legal and ethical standards as related to protected health information. So we ourselves are responsible every day, all day long, for promoting legal and ethical standards. We need to make sure, as brokers of information, which is a more common term that's being used, information brokers, we're the ones who make sure that information is there, it's available, it's accessible, and so making sure that we understand our role is so important. State and federal laws like HIPAA, regulations like Medicare, standards. Joint Commission would be an example of an organization who has standards for healthcare organizations. And again, Code of Ethics, AHIMA, other organizations like the American Medical Association, American Nurses Association, they also publish codes of ethics. It's great for us to be familiar as health information professionals with those as well, just because I think some of them complement what we do already, but it also helps us to understand what the roles of other health professionals are in healthcare. Organizational bylaws. Medical staff create and vote on bylaws. These bylaws are rules that delineate the responsibilities of a medical staff members. What's the requirement for how you're going to document? What's the timeline on documentation? What are your obligations to treat a patient? Rules and regulations are procedures based upon federal, state, and accreditation agency standards that clarify bylaws. And so that's just saying that other organizations like the Joint Commission may have some rules and regulations, some standards, and of course the American Medical Association may also have some rules and regulations that will also clarify what's in the bylaws. So that's really just saying that an organization, a healthcare organization, doesn't just recreate the wheel, reinvent the wheel. They will use those rules and regulations to build upon, to be a foundation for the development of the bylaws. Let's talk about the legal health record. A legal health record, known as the LHR, is the documentation of patient information that is created by an organization. Now, this legal health record may be different from one organization to the next, depending upon the information that's collected on a patient or the forms that are used. The LHR is used within the organization as a business record. So it shows what has transpired during the course of care. It's made available upon the request from patients or legal services. There's no specific set of regulations for legal health record, as I said. It may vary, but they must meet standards set by federal and state law. After meeting these basic standards, it's up to the discretion of the individual healthcare organization to decide what is and is not appropriate to reveal. So that's just saying that the legal health record, they've specified what is contained in that organization's legal health record, and they have the right to decide what is and is not appropriate to reveal. Now, does that mean that they can never release everything or include everything? No, it does not. But they have a right to have what they determine as their legal health record. Now, historically, the legal health record was simply the contents of the paper chart, but because more health care facilities are adopting electronic health records, using health applications for patient monitoring, tracking data to define and create a legal health record is becoming increasingly complex. So you just need to determine, even though we have some paper, we also have some electronic processes, and are those going to be included in the legal health record? For example, a lot of organizations have what's called telehealth. especially in rural areas that are pretty far away from the nearest hospital, the nearest provider, healthcare provider, so they're using telehealth. Now, it's up to the organization to decide, should that information be a part of the legal health record? Most commonly, it probably will because it does cover a course of treatment, but it is up to the organization to decide that. The integrity of the health record is so important. Documentation integrity involves the accuracy of the complete health record. So it must be accurate. It must depict what has actually transpired during the course of care. You can't document something that didn't happen, and if it happened and you didn't document it, then most likely it's going to be said that it didn't happen, or the patient didn't receive those services. Integrity of the health record encompasses information governance, and there's a lot of information governance literature available on the AHIMA website where it talks about governing information, looking at data, looking at information, using that in order to strengthen an organization to understand the patient case mix, patient identification, authorship validation. Who is the author? Who's the actual author? How can we validate that this doctor actually wrote this and that he didn't have someone else do it because he got so busy doing other things? Amendments, as we talked about earlier, and record corrections, as well as auditing the record for documentation validity. And this is one thing that is important to understand, that just because we go to an electronic record doesn't mean that we don't still need to audit for documentation validity. There's a lot going on with the health record in terms of looking at, was there cut and pasting done? Were there sections of the record that were, a physician used a drop-down menu to select a portion, or is he using a template? So these are things that are important, and that leads to my next point, where EHRs have customizable documentation applications that allow the use of templates. It's important to have some guidelines around these templates and smart phrases in order to maintain the integrity of the health record. Established policies and procedures such as audit functions must be in place. So, we just talked about the fact that even though we've gone to an electronic environment, that does not eliminate auditing. There still needs to be an auditing function that takes place. It may be a little more efficient because someone doesn't have to use paper, but as we know, we're still in a paper and electronic environment in most organizations. So, keep in mind that there still needs to be some auditing to ensure the integrity of the health record. Now, without these safeguards in place, records could reflect an inaccurate picture of the patient's condition. And this is so important. We need these safeguards because if we're using drop-down menus and templates, and there's some things that are already coded or stated in the record, we want to make sure that we have the right condition in the right patient's chart. We want to make sure that over the course of time, if a condition changes, there's documentation to support that. There's treatment protocols to support that. I think that it's important to make sure as health and professionals that we disseminate this information to providers so that they understand the necessity of reviewing and edited defaulted data to ensure that only patient-specific data for that visit is recorded. So I'm sure you can see the integrity of the health record is a big job. It means a lot in the health information profession. Understanding it is even more important. Compilation and maintenance. This includes state and federal rules and regulations developed by administration agencies. We kind of covered that in the prior slides, but just to highlight a little bit, state licensing agencies, we got vital statistics reporting, birth statistics, death statistics. Want to make sure that we understand the policies associated with retaining these records, with the retrieval of data. Accrediting body standards, such as, again, the Joint Commission and the American Osteopathic Association. They are accrediting bodies. They have standards. we need to make sure that we have reviewed those standards to ensure that we maintain records and that we have policies and procedures to support those. As we serve as a custodian of the health record, whether it's paper or electronic, we have some responsibilities depending upon the area of the organization that we work in, whether it's in acute care, non-acute care, the insurance industry, in a physician's office, etc. We must be able to testify to the foundation and trustworthiness of a health record. And I think this is important because who wants to testify to something that is not trustworthy? We want to make sure that during our day-to-day operations that we have a foundation and that our business, our documentation business is trustworthy. We must possess knowledge of and to testify to requirements to create a record. What are those requirements for creating a record? Upon admission or prior admission, keeping those records. How long should they be retained? What's the age of majority? Policies and procedures governing access to those records. Who can access those records? Who has a right to them? Is it only the physician and the nurse? Are there other areas or other entities or ancillary departments that need access to the information? There should be quality control methods, such as how corrections are made. And think about those corrections in an EHR. They're not going to be the same as they would on paper, where we draw the line, initial, make the correct notation, initial that, and write why we needed to make that correction. We need to make sure that our electronic health record has some steps to document what's going on. Why was this error done? Who did it? When did the error take place? When was it corrected? And an ER system should already have those things in place, but it's definitely something that we should be looking for and understand how to use. As a custodian of the health record, we may receive a subpoena ducis tecum to deliver and present original copies of records to the requesting provider in the case of a deposition or to the court at trial. So it's important to understand what a subpoena ducis tecum is actually. Does it include a court order? Does it not? Does it include an authorization? So it's important to understand that. So those are definitely terms that you need to highlight and have a knowledge of as you prepare for the RHIT exam. The health information custodian, or as I also called earlier, the information broker, under oath will be asked a series of questions in terms of, it's important to understand the legalese. It's important to understand the legal terminology, the policies and procedures associated with the legality of the record. So, you would be asked a series of questions to establish a foundation and trustworthiness in order to meet the business record exception and admit the record as evidence. Now, I've had the opportunity to do this during my career, and they ask you, you're always a little nervous, but you represent the organization as such, and you state your full name and business address. They'll ask you, are you the custodian of records? Have you brought with you a true and complete and accurate copy? Were all entries contained in the record presented today made by a healthcare provider? They may have a specific healthcare provider or a team of providers that they're actually bringing legal issue with. Has the record been maintained in the usual and customary manner? Meaning it wasn't taken home or taken out and someone took it home and documented, or wasn't missing. That's not normal practice. So it's important to be able to answer these questions and have a complete knowledge as the HIM custodian of what these questions might include. Let's just talk about the different types of requesters. And I'm sure you understand that there are requests made every day for health information. So we have our internal requesters, who might be patient care providers that work for a specific facility, patient care management and support like hospice or long-term care, physical therapy, and of course patient reimbursement may be making some requests because they I think that what I want to say here though is that these requesters may have access to this information, but the information needs to be monitored, even though they're in an, and I said that to say, in an electronic environment, maybe they can just go to the computer, but there needs to be someone who is acting as a custodian of records who monitors the process of who has access to information and for what. And of course, we have our external requesters like the Social Security Administration, employers, insurance, legal, associated with the attorney's offices, things like that, and auditors who may put in a request for information because they're auditing the course of treatment, they're auditing the bills associated with that. So it's important to know, for us to know who our requesters may and may not be. And how do we handle those? How do we handle those? Do we have an authorization? It's important to always ask yourself that question. Is an authorization required? Risk management. So the risk manager is responsible for gathering information and managing general liability incidents and liability claims and lawsuits. They're also responsible for handling incidents as it relates to internal processes. So if someone gets hurt on the job, those kinds of things, or someone does something that's not following the code of ethics established or the bylaws, risk management would get involved. But they're responsible to manage and minimize risk exposure. So it's important. I don't hear a whole lot about risk management like I used to, and that could be just because of the change in jobs. But I'm sure that risk management is as busy as ever, especially since we deal with a lot of electronic processes now, and maintaining access to the health record and the importance of maintaining the record. Now, risk management utilizes abstracting and auditing as a risk management tool. They look for errors, abnormal findings that were not addressed, and policies and procedures that failed. What happened during the course of treatment that this policy wasn't followed? Or incomplete patient records. I mean, incomplete patient records can be so costly to an organization. Not only because it impacts patient safety primarily, but also if it wasn't documented, it didn't happen. So how can we bill for it? How can we be reimbursed for it? How can we validate what we've done as a healthcare provider to a patient? So those are some things to keep in mind as you think about risk management. I think it's important for health information professionals to be familiar with risk management. Now, let's talk about the paper record. Hardly gone and definitely not forgotten, but these are some things that we need to make sure that we have still in process, and we still have some familiarity with handling paper records. Because I can tell you that organizations, systems, the electronic systems, technology fails, it goes down for periods of times. Having processes, procedures in place to still react or utilize the paper record is important. So these are just some things that we need to adhere to in terms of how we're going to make a correction in a paper record, specifying the date and time, and signing the correct entry. Document the reasoning for the error. Was it made in the wrong chart? That needs to be documented. And that could happen, especially in a paper environment, but it happens in an electronic environment too, because there are a lot of patients who have very similar names. So it's important to still have a knowledge and a respect for that paper record, because I think it's going to be around for a while. Electronic records. Again, we talked earlier about the mechanism or process to correct the technology or electronic process to correct an error in EHRs should always be included. Storing that original note and any changes posted. Having the ability to see on screen that, yeah, this is the original note, but there's a change that has been posted or an amendment that has been posted. Date and time of the user making the edit. Reason for the change should all be documented, because if this record gets called into question for any reason, we need to be able to attest to the fact that this was an error, this is why it happened, when it happened, who it happened to, and this is the reason. These are things that are so important that will always be around, that health information professionals will always need to manage. I'm talking a little bit more about the HIPAA privacy rule. And it grants the fact that it grants the right for the patient to request an amendment to their health record. Um, just want you to know and be familiar with the fact that a covered entity can deny that request. They can also, if the entry was not created by the CE, and that just means that the covered entity was not the originator of the medical record. Perhaps the patient moved from another facility or they moved from another state where they were seeing another doctor and they were the originator of the record. The patient cannot ask the uh, current provider to amend or make changes to another provider's records. Addendum to the patient record. From time to time, information has to be added to a patient's record that will clarify the patient's condition. And I think you just make those addendums going forward and be clear about what that addendum is and how it has impacted the patient's condition. Consents. Now these are important because consents are going to be around, and they're that piece of the record where the patient whether the electronic record, even though they may have an electronic record, they still may be printing the consents for a patient to sign, unless they have, the capabilities through the technology for a patient to sign those consents and read them and everything. But it's required by federal, state, and accrediting agencies that patients consent to treatment. Can't just, give a patient what you think they need if they're able to understand and articulate, and they're competent. You've got to be able to get their consent to treat them. Informed consent, the process of advising the patient about treatment, surgical procedures. They need to be informed. We have a right to be informed. These things are required. Admission consents. Again, the consent to treat and surgical consent. Those are some of the consent forms that we may sign upon admission. Consents, healthcare power of attorney, advance directives, DNRs, etc. Just be familiar with these type of things. What is an advance directive? What is the Patient Self-Determination Act of 1990? Providers must notify the patient 18 years and older that they have a right to an advance directive. Advance directive, what is it? And I more recently completed a legal document to determine, what I'd like to have happen should I become ill and there's no ability to revive me. I think it's important that people understand that they do have this right. It's kind of tough when you spring it on someone during the course of, difficult times. But typically, I think healthcare organizations call you with what's called the pre-admit process, and you do some of these things prior to actually the day you're actually admitted. Do not resuscitate. Be familiar with what a DNR is. Patients may have a DNR on their chart. Someone in the room who's associated with the patient may not want that DNR order to be honored, but if a patient has decided to have an order documented, which is recorded by the physician, which instructs medical and nursing staff not to try to revive them, then it will be honored. Keep in mind that patient records are usually admissible in litigation or judicial proceedings. A court order is issued by the judge, or a subpoena ducis tecum issued by other sources are used to obtain records for legal action in courts with jurisdiction. A subpoena ducis tecum usually requires a patient's authorization. So it's important that you look back, you review not only the requirements associated under Domain 6, which is published in the HIMA Certification Candidate Guide, but that you also review these terms, these legal terms like subpoena ducis tecum, that you understand the authorization, what should be included on the authorization. Has the patient signed it? How long is the authorization valid for? And again, these requirements are going to vary from state to state, so it's important to understand these things according to the state that you live in. I hope that as you're preparing for the RHIT exam, you connect the content between your courses, that you take time to understand that every course that you have had has some bearing on the other. As you connect that content and you pull together those theories and concepts that you've learned, that they all add up, that they all have meaning as you move forward. I think one great example that I always use is that when a student comes into the health information profession and they take those entry-level courses like health information technology, which is HIT 120, they begin to learn about healthcare and healthcare processes and the people who are in healthcare. As you move forward, then you use that information and you're moving into like your coding classes, and then you start to understand, what a coder is, what it does, what they mean in healthcare. And then you look at the medical terminology classes that you've had, and you see that you definitely have to know medical terminology in order to code. You have to understand the body itself. And as you move forward, those things, you use those things to build and grow in knowledge in other classes. So, it's the same as you study for the RHIT exam, connecting the content not only to the domains, but to each of the points listed or things that are covered, the tasks that are covered, utilizing your textbooks and your syllabi from your courses to also establish a pattern as you study and you build your study plan. So I'd like to thank you for your time. Thank you for listening, and the best to you all.